Greetings, everyone. Thank you. Thank you for joining a moment into a movement. My name is J Love, and the movement was birthed the day my son was wrongfully incarcerated for a crime that he didn't do. And that birthed this movement, turning a moment into a movement. And welcome you if this is your first time. With us today, we have attorney Hugo Mack and Edward Sanders. Yay.
Good seeing you. Good seeing you.
It's great being seen. So today, we're going to talk about, again, another week of junk science, forensic fraud, and wrongful convictions. And so before we get started, I'm going to have you guys introduce yourself. Attorney Hugo Mack, we'll start with you.
Well, our leader, our queen. It is so good to see you and be with you again. I mean, look, you are our leader, J Love. Don't deny it. Don't deny it. You know, you've given us a great platform. You know, and I'm so appreciative. I'm so appreciative. Well, my name is Hugo Mack, criminal defense attorney, former public defender for well over a decade. A man who believes that we have to keep fighting the fight of faith for justice in a system that is skewed against us from the very beginning. Systemic racism, as American as apple pie, as Malcolm would say. So we have to keep on the fight for people being treated fairly. And this is not just about equality, this is about equity. There's a difference. There's a difference. So this is about equity in the system, all right? Because everybody does not start off at the same starting mark. It's not a race. When you have people that start a 100-meter race at the same time, the same place, you might say that's equality. But if you have some of the runners that are denied shoes, denied training, denied nutrition, denied opportunity, despite the facade of equality, you have no equity. Mm-hmm. So equity in the system is what I'm all about, what I've dedicated my life to. And so that's why I'm here, and I'm glad to speak up for the wrongfully convicted and overly convicted. Every bit the victims as anybody else, anyone else in society.
Absolutely. Thank you for that. Yes. Hey, Edward, how are you today?
I am doing fine. And as Mac point out, attorney Mac Street, as he point out, I'm glad to be here. I'm always taking and pulling his Shango out. So if you don't remember who attorney Hugo J. Mack is, just remember Mac Street. My name is Edward Sanders. I'm a former juvenile lifer without parole. I've been home now for about 3.5 years. I came home in 2017 of July. I went to prison in 1975. So I went to prison about at the age of 17 and returned just before my 60th birthday. I'm a recent graduate at the School of Social Work in Ann Arbor. I'm an accomplished paralegal. And I'm presently employed at the University of Michigan School of Information, working with returning citizens and other related criminally justice-related work. I'm a community activist. I'm a long-term resident of the city of Detroit, with the exception of my absence due to my incarceration. And I'm glad to be here tonight.
I'm glad you're here too.
Amen.
So we have been talking about this junk science, and I didn't know that it was going to take us on down this road so much. Attorney Hugo Mack, can you just talk to the viewers about junk science, wrongful convictions, and a little bit about if you have anything on shaken baby syndrome? That's what our focus is today.
Well, let me deal with the last topic first, all right, in terms of shaken baby syndrome. For 6 years, while I was employed in the public defender's office, I was the juvenile public defender. And that meant that I represented juveniles that were accused of wrongs that we would consider misdemeanors and felonies. But juveniles actually aren't adjudicated misdemeanors or felonies. They're infractions, but they carry a penalty. And as anyone will know, you can be waived as a juvenile to be tried as an adult. So, and one of the responsibilities that I had, in addition to representing juveniles that were charged with what we consider misdemeanors and felonies, was to represent the county's neglected, abused, and violated children as guardian ad litem, which is an attorney that is appointed by the court to look out for the best interests of the child. Because in any kind of neglect and abuse case, the state is there. Could be the attorney general, for example. It could be the county prosecutor working in league with the Department of Health and Human Services, bringing charges of neglect and abuse against a parent. So they're lawyered up. The parents have a right to a lawyer. They're lawyered up. Well, the child also has a right to a lawyer. So they're lawyered up. So in terms of shaken baby syndrome, part of my responsibilities when I felt appropriate was to aid and abet in child abuse and neglect cases where I felt the child had been violated, harmed, dropped, left in a car for hours while somebody's in a store. I mean, anything along that line, and which includes being injured and having to go to the hospital. So I'm very familiar with shaken baby syndrome, and I must tell you that oftentimes I utilize quote unquote experts on shaken baby syndrome to try to explain how a certain head injury or a child brain injury could occur. Now, that is not to say that there's not error in that analysis. I mean, in my later research, I realized, for example, I had a case where they were saying a hematoma inside a child's head had to come from impacting a child's head against the side of a wall. But come to realize that certain kids have brittle bone syndrome. Their bones are just brittle, and you could just hold them normally, and a bone could break or fracture without any kind of intent on the part of the parent. But yet, if you're not aware of that, you could say, oh, this is a sign of abuse, when nothing could be further from the truth. There are kids that react to medications differently, congenital diseases that can give a false reading of these sort of things. So in terms of me, my use of shaken baby syndrome was where I felt, in most cases, a child literally been rattled. I mean, just a parent got angry, grabbed that child and said, you stop crying, perhaps not intentionally hurting the child, but sometimes that did result. But I do want to say this about shaken baby syndrome. In every case I've handled, and I preach this all the time, don't just try to rely on that to say there's abuse. There's other things you need to look to, just like facial recognition. You can't use facial recognition to say somebody was at a party store and just rely on that. It's too flawed. So shaken baby syndrome over the years has been shown to have flaws in and of itself, you see.
Right.
So that's important. So that's my experience with shaken baby syndrome. And in terms of the junk science, the only thing that separates junk science from quote unquote legitimate science is money and opportunity. Because what happens is these people are all, when I say people, I mean researchers, always trying to come up with a method of getting funding for some project or some novel idea they've come up with. And a lot of it has been junk science, where they can get like states or state police, to buy into this quote unquote technology where they say prove something when it really doesn't prove it at all. Because a lot of the problem is, who are you testing? What is your database? Just like with the COVID shots right now, where they say, well, it's 90% effective. Well, it all depends who you're testing. If black people aren't in that test group, or Hispanics or indigenous people, you're gonna get a false reading for them. You might say, well, it's 85% for everybody, when for people of color, really it'll be 50%, because you have a bad test group. That's the same thing with junk science. So anytime I come across something with a prosecutor or a new theory they have, where they say they're relying on this technology, automatically start out with the presumption that it's junk science.
Right.
And it can prove to me that it is not. And it's not that hard to get a person convicted in the United States of America. Not hard at all. J Love, you and I could conspire against Brother Sanders right here, and declare we saw that man going into that party store and rob it. That man could have been in Iowa. And I'm saying if it comes down to our word against his, you and I have a great chance putting an innocent man in the penitentiary. That's really how easy it is to convict somebody, unfortunately, in a jury system in America. And judges are really no better.
You're right. Edward, did you want to say something before I go to the video? Because I want.
I'll let you go to the video and come back afterwards. If you like.
So I'm going to go to the video, and then we're going to bring on Arthur Bean, who is also an expert, an investigator in this field of shaken baby syndrome. Okay, we're going to.
Experts describe violent shaking as an insidious killer.
The teenage au pair is accused of murdering an infant.
So she grabs Maddie infant and she shakes him.
Ferguson is accused of shaking his baby to death.
Police say Watts shook the baby,
shook his daughter Presley to death.
You can't cause brain damage by shaking without first causing neck damage. I have never seen a case in which there has been neck damage. None.
Scientists question that syndrome.
If you ask yourself, could this be physically possible? The answer comes up, no.
Physicians across the nation are looking at the science and questioning this.
There are other conditions that can look just like it. The MRI opened the door from what we said could only be due to shaken baby syndrome.
It is controversy about whether people have been wrongly accused of child abuse.
Audrey Edmonds convicted.
Man convicted of killing his 3-month-old son.
People are in prison and their convictions are based on science that has now been disavowed.
Why is the only person we're concerned about a person who might have been innocent who went to jail? What about the babies who are killed?
They have an ideology that they have adopted. It's we are the ones who know how to recognize child abuse.
We know it was massive injury to the brain from violent shaking.
Let's look into what the real experts are saying. Neurosurgeons, neuropathologists.
Shaken baby syndrome is in the realm of mythology.
It threatens the entire shaken baby syndrome industrial complex.
I had absolutely no idea what I was up against.
Wow. Thank you for joining us, Arthur Bean. Can you introduce yourself and tell everybody what it is that you do?
Yeah, my name is Arthur Bean. I work for a law firm out of Oklahoma City, Deborah Hampton's law office. And I took an interest in these type of cases back some time ago. It's a pleasure to make y'all's acquaintance, too.
Pleased to meet you.
Oh, great meeting you.
And I find in these shaken baby cases, there's issues of suppression of evidence, MRIs and CT scans and X-rays, usually every single time. These children start developing problems. Their mom and dads take them to a hospital or a clinic. The doctors misdiagnose them with a problem, and not all the children that we deal with have been deceased, but in the babies that have been deceased, in the autopsy reports, the medical examiners find illnesses that lead a person to believe that these babies had meningitis. So we're pushing today for DNA testing of the blood of the babies of these people that have been convicted. Behind this science, you know, we allow these doctors to testify to the ultimate fact without given what they predicated their claims on, like a skull fracture, but you don't have the X-ray to back the skull fracture up. So we're just going to generally accept, like under a Fry, even if it's a Dalbert state, we're just going to generally accept the expert's testimony as being reliable. Oh, if the expert said it, he's the doctor, it must be true. Don't necessarily mean it is. we can determine if a baby had meningitis by an MRI with contrast or without contrast because of the loss of the differentiation in the gray and the white matter in the brain, and what the meningitis does. Not saying that every shaken baby case is meningitis, but there's usually a underlying bacteria which caused the baby's death, and each baby appears to have had sepsism. So it's a theory that the shaken baby syndrome is a medical service provider's way to escape liability for negligence.
I believe that.
If they let us have the DNA, if they just let us have access to the biological material, we can show that there's a reasonable probability that the outcome of the trial would have been different, and that the state may have chose not to even prosecute those people. But we have a fight. We have a fight to getting that access to that evidence.
Look, I agree. Can I say this?
Okay, yeah.
I agree 100% with that. And to its credit, I think because of pressure by people like Mr. Mean and others, to a small extent myself, the University of Michigan in their child abuse and neglect, their team, their doctors now supposedly go through and I've seen some of the paperwork, whether they actually do it or not is maybe up to debate, where they have an entire screening protocol for like meningitis or other things that could have caused it. Now, whether that's just a CYA for them or whether they're actually looking, to see if there's some other cause for this injury, I don't know. But at least it's a first step to getting them to acknowledge there are a whole battery of causes that could give you a false reading that this child has been abused when it really hadn't been abused at all, you see. So at least it's a start here in Washtenaw County. So that's a good thing.
Edward?
I've been listening to both Attorney Ben and Matt, and I paid very close attention to the video that you took and showed. And one of the things that I want to capitalize on what Matt took in reference was the fact that the problem is where you over rely. If you take and solely rely upon what you consider to be scientific evidence, and the problem with over relying on evidence that is beyond the general knowledge of jury is unconstitutional. And what I mean by that being unconstitutional is that you have a right to a jury, and it's the value of the judgment of those jury members, not professionals that come in and give testimony. Okay, you don't necessarily have a right to them, neither you nor the prosecutor. You both have a right to attorneys, particularly the accused. The accused have a right to take and call attorneys, witnesses in their defense, but you don't have a right to take and throw a pyramid of evidence in front of a jury that's beyond their common experiences and that solely put them to the mercy of the explaining of that their theories or their hypotheses strictly on professionals. When that's did, you are taking away the judgment of the very jury that the defendant has a right to. The defendant has a right to a jury to take and be able to use their common sense. Okay, so any cases where you have an over reliance or evidence that's supposed to be on science, in my opinion, is very questionable, particularly if that science is a novel science. Particularly if it's a novel science. That's what I would take and contribute to the discussion that's been said thus far.
So, Mr. Bean, we have, so the science within the last, 20, 30 years has been refuted. They're saying that that what they based it off of is not really reliable. So why is it taking so many people so long to be exonerated?
Because your court systems don't want to let those people out. They don't want to admit that they made a mistake. It's hard for somebody to say I was wrong.
Right.
It shifts the liability on the political subdivision of the state. They don't want to pay them claims.
Right.
You know, in these shaken baby cases, we see all kinds of different, and Mr. Black said something about the Michigan. They seem to be leading the way with shaken baby syndrome cases. You know, he wants to take Dave Moran over there as an excellent person, but he likes to take the cases that don't involve the DNA evidence. You know, I run this theory by Dave about checking the baby's blood for the DNA of the organism. If we can test the blood, a lab in Lubbock, Texas can test the blood for 25,000 organisms that would live in the blood causing disease. Well, if we can prove that the babies had Haemophilus influenza, you know, 89 countries require vaccination for these infants. And most of the infants that we see that die from shaken baby syndrome are around 4 months in age. And so now we got these child abuse experts that have decided, well, I'm going to be a child abuse expert. So if they never find child abuse, then how are they going to be an expert? So they become biased in their own field. Dr. E.T.L. Dror and Dr. Greg Campican from the Ohio Innocence Project, but E.T.L. Dror is a neuroscience researcher and writes about different biases, and in the contextual information, making experts vulnerable to making erroneous decisions. You get a baby that's checked into a hospital, one doctor makes the determination that, oh, it's shaken baby syndrome. Your next doctor, he just comes along and follows suit and relies upon the next doctor's finding. Before the charges are submitted, next thing you know, we make somebody a murderer that haven't even done nothing to their kid.
Right.
And it's prosecutorial misconduct that lies behind it, because the prosecutor is the person that should ensure the reliability of the evidence. Sometimes even the judges get misconfused with scientific evidence. They're supposed to be the gatekeeper.
Right.
That went back to the proposition that I made, that anytime a case is solely relied or heavily relied upon evidence that is beyond the comprehension of a normal juror, then the judge have to consider how much of that to allow in as opposed to other evidence. And anytime you're talking about cases that's dealing with child abuse, most of the time there's more evidence outside of this so-called scientific evidence. There is common sense evidence. You taking formal wounds on a child that's weeks or days old. You are taking physical evidence of abuse is normally a constant sign, either in the house or on the child, or either in the disposition of the parent. So it's never no one thing that you have to bring some scientist in, and somehow he or she can see beyond the exterior of the child where there's no evidence of any injuries, and they somehow miraculously take and be able to scientifically explain to you the abuse that the child went through. That normally don't happen in abuse cases. And then they explain things that you can only explain with what they call science. That's where the problem lies at. You know, I done served time with children that had experienced trauma. Anytime you talk about a population here in Michigan, we have over 370 plus formal children that spent time in prison. Many of them I spent time with. Many of them I realized that they have been through trauma. You know, people who have experienced trauma cause trauma. Okay, so all we done did in this state is mask the abuse. We have taken children that have experienced abuse and we have put them in prison. Okay, and that's just a masking of abuse, but you can see the evidence of that. You see physical evidence of their childhood, or how they came up and was physically abused, and you see the mental part. Okay, if that's absent for a person to have that personal experience, I know something is wrong. You didn't explain to all of this groups trauma away, but somehow you identify trauma in a group that doesn't have any evidence of scars other than what you can take and phantom with a so-called scientist.
Arthur, do you have?
Sometimes these doctors allege that these kids have bruises on them too, but that sometimes the bruises can be often explained by what happens inside the blood. Just because a baby looks like they got a bruise, it doesn't necessarily mean it's a bruise.
Right.
Right.
But doesn't like these different boards and organizations that have benefited off of shaken baby syndrome, don't they have a lot to do with it fighting back against the science that the changes that people are finding that is not true, in your opinion?
Even the man that was principally responsible has admitted that his determination was kind of flawed.
Yeah.
Yeah. But these doctors are financially motivated to find abuse. If they can escape liability, because a child died from medical negligence, a lot of times these deaths can be prevented with these children.
Yeah, I agree. And along that same line, I just want to reiterate what was said earlier, I believe by Mr. Bean, is that I can talk about the University of Michigan, for example, okay, where they've got entire departments on pediatrics and child abuse. Well, just by the very name itself, the Department of Pediatrics Child Abuse, it lets you know that that's kind of the premise they work off of in the beginning. It's not the Department of Pediatrics investigating cases, it's the Pediatrics Division on Child Abuse. So yeah. I think it's almost such a subtle thing, all right? It's such a subtle thing, just like coming into court all the time when they're introducing people to the jury. Prosecutors are notorious for saying this defendant and this is Mr. Jones' victim. You see, if a defense attorney lets that go by, that's a very subtle thing because it conditions a person, a juror, into thinking, well, these are the names of the people in the play. This is the defendant and this is the victim. By its very nature, a victim is somebody that's been done wrong, okay? So when everybody starts agreeing to the name of the players on the field, sometimes the outcome of the game has already been determined, okay? It has already been determined. So that's one thing I do beforehand. I said, Judge, please don't allow this prosecutor to refer to this person as a victim. You know, if you want to say complainant, or even if you want to say person to have alleged to have been wrong, but don't start conditioning the jury offhand to say, oh, this is the victim. And hear the judge say, this is the victim. So, and I just want to say, I've seen it time and time and time again, where these people's paychecks are determined by being in these departments and finding cases of child abuse and neglect scientifically. These doctors get grants and correct. And so the more and more you say, I've testified 100 times as an expert, and I know that 99% of that time you've testified an expert, you said there's child abuse, then you've already set the stage for your bias. You've put it out there. The only question is the defendant or the defense attorney astute enough to catch that and challenge that and try to bring that reality in front of the jury about that implicit bias.
So once it's labeled as an abuse, it's hard for them to turn that off.
Absolutely.
Yes.
Absolutely.
Because that one doctor follows suit with the next doctor, even though in some cases you'll find that that even though you may get a report or something, the defense attorney never even read the reports, because there may be something exculpatory in the report, such as we need to refer the infant for further antimicrobial therapy or infectious disease consult. That would be exculpatory to first-degree murder.
I think it's also interesting that when you get a person that come before the court and say they have testified so many times, you take and inquire whether or not they ever turned down an invitation to testify, and whether or not they ever testified for the other side. And why is it that you only testify for one side and not the other side? You know, those type of questions are very relevant. You know, why are you only called for one side? And have you ever turned down an engagement because you didn't believe in the prosecutor's theory of the case? You know, not just simply that you turned it down or you wasn't available, but because you did, and you would take and bring out the bias, the fact that the person is like, you never turned down a drink, you know, because you looked. This is your dependency. And those things are very interesting, just as taking and having the court not refer to your client in any derogatory terms, to take and acknowledge him or her in terms of their humanity. This is a science, in my opinion, that is born out of gender. This is a gender-based science. Even though men and women have been prosecuted under it, it is a gender-based science. It's a judgment against women and mothering. This is what this science is based out of. If you remember in your video that you showed, one of the videos, it showed you what it wanted you to see. It had this thing that's supposed to have been a child, and it's showing you what's happening in the head. But when you looked at the neck couldn't even move. Okay, the neck couldn't even move, and that wouldn't happen with a child. You know, if you can recall as a child, when your young brother picked up your baby doll and shook your baby doll, remember the head of that baby doll is bigger than anything else. And what it does is it wobbles back and forth. You can't have all the abuse that they claim to be in the head and not have injury to a neck. If you done one of these things to a child, the biggest thing on the child is a head.
Yeah, I read that and saw that in as I was studying this, that a lot of these cases the babies don't have neck injuries.
And I've not seen one that there was an eyewitness. And also another common thing between these cases are that most of the babies are on some type of state insurance.
Wow.
And they're getting state assistance.
So they're already labeling. They're already labeling you if you're on state assistance, or you're a poor mother and you can't handle the stress of your baby crying, so you just shaking the baby.
And it's not always the moms that get prosecuted for it. I mean, dads and boyfriends get prosecuted for it too.
Yeah, and I'm glad you mentioned that, because I can recall a case. It was maybe 3 years ago, 2 or 3 years ago, and it was in Detroit. And the young gentleman took the baby to the hospital because the baby didn't wake up. He tried to wake the baby up, and he called the ER. I think attorney Lillian Diabo was his attorney. But anyway, the young man, they immediately took him into custody. And at the arraignment, that's when he found out that his baby died. Well, later on, as the case goes on, I mean, they had the mother, they try these things in a court of public opinion. So they had the mother on there, and the mother was saying that, the son couldn't take care of the baby, and the mother was an unfit mother. And they did all of this, and come to find out later on that the baby didn't die the way that they said. And there was no apologies. You can still find this on the internet right today. There was nothing. But immediately, because he was a young kid, he was, 20, 21, with a little baby. They was living in a hotel. Immediately, the bias that he did, he rolled over on top of the baby. I think that was what it was.
Yeah.
I think you got somebody you're going to come bring on that was exonerated from it too. She got a story to tell.
Yes, I see. Tia, why are you in the audience? Reverend Tia. Why are you? She says labeling parents as incompetent due to low income. Yeah, I've been waiting on her to come in. She hasn't came in yet. But you can talk a little bit about her case. She hasn't came in.
Well, I know that she was exonerated by the Michigan Supreme Court when they remanded her case back with instructions to dismiss for insufficient evidence of child abuse. Pretty much shaking the baby.
And I have a question, maybe Attorney Hugo Matt or Dr. Ben or Edward. How hard is it or easy is it to win an appeal?
Well, I mean, I can just talk from my experience. Next to impossible. All right. You know, I've done appeals on criminal matters and child abuse matters also. And the thing of it is this. The reality of it is, under the state constitution of Michigan, for example, in a criminal case, you have a right, not a, if they choose to do it, you have a right to an automatic appeal to the Court of Appeals, all right? So, but you don't have a right to an automatic appeal to the Michigan Supreme Court. You have to get leave to appeal.
Yes.
Which is very, very difficult, you know, and over 93% of applicants for leave to appeals are summarily denied. I can tell you that from personal and professional experience. Not only do they deny it, they'll deny it in less than a paragraph.
Yes.
You know, the issues that the defendants presented are not sufficient of import to the people of the state of Michigan, words to that effect, and therefore this applicant for leave to appeal has been denied. But you see, the problem is, and I know we're talking about shaken baby syndrome, but I think we also need to talk about criminal convictions, period. All right.
Thank you. Yes.
And we know shaken baby syndrome, in terms of child abuse and neglect, that's not a crime. In terms of terminating parental rights, that's not criminal. But like child abuse first degree, which can result from shaking a baby or harming a baby, that is criminal. So let me preface my statement first in terms of criminal law. In the state of Michigan, the problem we've had, and if they want to reprimand me for saying this, let them. The problem that we've had is that we have people that have been running for Court of Appeal judges and Michigan Supreme Court judges as if they're running for sheriff. Okay? And, you know, I expect a sheriff to get up and say, we got to do something about crime. We got to have law and order under control. You know, the streets aren't safe. But it literally sickens me to my stomach when I see in my state that I love, dedicating my life to certain people in, when I see people running for Supreme Court and Court of Appeals that have got commercials castigating their opponents for finding somebody not guilty because of insufficient evidence, or proof beyond a reasonable doubt, or granting a motion to suppress, where police have clearly violated the Fourth Amendment. You understand? You know, clearly violated it. And then that person is labeled as being soft on crime. So see, we have a systemic problem in this nation where a lot of us culturally, we will stand by and see an orphanage burn without lifting a bucket of water to put the fire out, because something fascinates us as seeing other people squirm, you know, other people being taken down on the hot seat, until it happens to you or your family. Then none of that excuse me, it's so damn it's so funny then. So when you got a Court of Appeals that says, look, it is harmless error, it sickens me, because every time I go up to deal with an appeal, I run into that harmless error. It's like a big old barn that's big enough, you know, you want to be sure every mosquito can get through. All right, harmless error. So that when I say next to impossible, I'm just being for real, because they will excuse all kinds of prosecutorial misconduct, perjured testimony, tainted evidence, coached witnesses, badgering a witness by the prosecutor it really didn't affect the outcome of the trial. So that is a big problem, and I got to call it real.
And so this is a reason why we have all these innocent projects and conviction integrity units. If we wouldn't need them if people could, get an appeal or get their case reheard. But I think I read it was like 6% of people win appeals.
And a lot of times, talking about what Mr. Mack just brought up, the harmless error, and a lot of times these appellate courts will engage in an unreasonable application of an harmless error under Chapman versus California, and it'd be unreasonable. We last year we prevailed on a case out of the Sixth Circuit in this for over Michigan, Sturmer versus Warren out of the Sixth Circuit, and we prevailed on that. They found that she was entitled to a new trial, but the federal judge Arthur Tarnow out of the Eastern District of Michigan addressed a trifecta of constitutional error with her defense attorney, with the prosecution, prosecutorial misconduct, and with appellate counsel's failures to raise certain issues too. And the Michigan Supreme Court, by their summary rejection of and even the district court summary rejection of issues, was an unreasonable application of clearly established federal law, because there's no analysis of the claims to show that you resolve the issue to determine there was no prejudice to her or to any defendant when they analyzed these harmless error claims. A lot of times, if you just argue it, you can show that there, but then you have the AEDPA, which erects what the states call a formidable barrier. I've argued, I've taken it to an extreme, and I've argued that if a state court opinion violates 2254D1 and 2, that should be an extreme and rare circumstance which should entitle that person to equitable tolling. Regardless, I mean, you shouldn't be able to bar fundamental claims such as that,
Right. And I'm sorry, go ahead, sir. I'm sorry.
No, go ahead.
Yeah, and see, in 1992, that omnibus crime bill, you see, crime bills that were going on, it made it increasingly harder for people that are incarcerated, for example, putting severe time limits on when you go into federal court, on habeas corpus. It made it very, very hard. And plus, with the Engler administration in Michigan, by the way, the worst governor in the history of the state of Michigan, I might add, in terms of any black, brown, or poor people, I might add, it made it hard in terms of inmates facing, well, it's a frivolous lawsuit, having their cases summarily dismissed. And then not to mention the punitive measures that go on by the Michigan Department of Corrections against people incarcerated who have the temerity to try to file a habeas corpus or to try to file in the Michigan Supreme Court on their own, or heaven forbid, bring allegations of staff misconduct, or corruption. In my own penitentiary experience, I was resoundingly retaliated against for often over 300 grievances and 12 lawsuits, okay? So these are the kind of things that people will not tell you about unless they're on the inside, or they know somebody on the inside, where you have so many people that have been done wrong. It breaks my heart. But they're terrorized because you better dang sure believe the department knows when you filing papers against them, okay? So that word gets back to the warden. That word gets back to that a-hole sergeant, okay? Brother Sanders knows what I'm talking about, you understand? That can make your life hell, live in hell. So it really takes a strong man or woman or somebody with support staff on the outside to try to stand up and fight from inside the penitentiary, because you're really fighting inside a tornado is really what you're doing.
And let me add this. The two attorneys here both have pretty much described your appeal of right, okay, on your direct appeal. And they have explained how difficult it is for them to take and file appeals on behalf of appellants immediately after their conviction. Even worse than that is what is called a post appeal in Michigan, or pretty much anywhere else in the country. But here in Michigan, the guys that are in prison after after the men and women have had their direct appeals are almost next to impossible in terms of any late type of appeal. Okay, we have what is called a motion for relief from judgment, which in shorthand they refer to as a 6500 motion, which is the subchapter that is found in the courtroom. Those motions are pretty much thrown in the garbage can. Judges pretty much do not even read them. And you could have filed a letter, you could have wrote a letter to the judge and it made an inquiry about your case and then filed a 6500. They'll treat that letter that you wrote earlier as your motion for relief from judgment and take and deny it and say you previously filed one. And you wind up spending the next 2 or 3 years trying to explain that you never filed a motion with this court before. That the only thing that you ever wrote on a particular date they refer to is a letter. The appeal court then had to step in and say, hey, that couldn't have been a motion for judgment because a motion for relief from judgment have to include a request for relief. You can't just simply argue about something and complain about something. He had to meet the legal standard of asking for release. But this is an example of how garbage-free they take and treat claims from people who are incarcerated is next to impossible. The only real success that I found as a jailhouse attorney in filing motions on behalf of people that was incarcerated is even when they had good issues, I would advise them, don't file it. Ask the court to appoint you an attorney prior to filing the motion. Say that you have found sufficient merit to good cause and prejudice, and that if the court would appoint you an officer of the court, you will have that officer of the court to take and properly present it to the court and tell the court that you believe that the requirements of the good cause and prejudice is difficult for you as a layperson to file. Okay, that's what I advise guys to do. Not to take and rush in there and try to play your own attorney and try to get inside of the court with your argument, no matter how good it is. I have watched guys since I've been home from prison come out whose cases I worked on while I was in prison, where the courts had repeatedly denied their motions and so forth. But thank God I'm seeing some of them eventually come out of prison. These were the guys that I knew was actually innocent for crimes which they was accused of and which nobody was listening to them. Nobody. Even when there was a train of evidence to take and show that the police in their case were lying, you know. And so I'm glad to take and see that, but it's difficult. And like you say, this is the reason that we have all these organizations. They have literally substituted our appeal process.
Exactly. I see Linda Sturmer said the state courts are rubber stampers.
Yes, they are. Yes, they are.
So, yeah, so that's why we have people 16 years, 20 years, 30 years, 40 years, because they had to go through these groups just to be heard. You
have to wait for years for them to take and sort through who cases they're going to accept. And so a lot of the guys are even discouraged. You know, you're an innocent person and somebody tells you to submit something that you got to wait several years and they ask you not to file anything while you waiting. You know, innocent person generally can't do that. And a lot of them don't. They go on and file things even while these organizations are saying, we'll get with you later. You know, and many of them don't hear from them for 4, 5, 6 years, you know. And I didn't hear people come to me and I say, this is a good case to take to the Innocent Project. And they tell me I did go to the Innocent Project. And I tell them, well, then wait. And they was like, no. They'll show me how old their letters are. They'll tell me how long the other person has been waiting. And then you can't convince them to stay still. These people are like, I'm innocent, man. I'm not going to sit around and wait on this. And so many of them don't. And then some of these projects, sometimes they will refuse to take the case. You know, if they get involved and they see the case is doing something, then they say, no, We are here as the last resort. When you no longer have an appeal, when you no longer have access to an attorney, etc. And sometimes it works out for the guys, but most of the time they tell the guys you can't even get in because you jumped and did something other than what we asked you, and you didn't wait. And so sometimes they don't even get assistance from those groups.
Wow. I'm reading a comment from Linda. They are elected officials that rely on popularity and not justice. People must continue to the federal court.
And sometimes the federal court is not providing that. You know, sometimes the federal court is not providing, and sometimes they're just slow at it. You know, and you may mention that, you know, we're talking about innocence and not just simply, you know, shaken baby syndrome, but we're talking about innocence in general. If you look on the State Appellate Defender's Office web page, for an example, they will tell you the millions of dollars that they saved the state of Michigan by taking cases back to the court and getting sentences brought down. Because many times people are sentenced in excess of what their crime is or what their actions were. And but for somebody stepping in between that, the state will be spending more and more money to take and house these people for longer and longer time. So they play a good role even where they don't get the conviction overturned. And remember, even though we talk about people who are guilty, who are convicted but are innocent, there are more people in the numbers of the guilty pleas than there are in the DNA or any other kind of evidence. Okay? There are more there because 97%, anywhere from 94 to 97% of the people in state and federal courts plead guilty. Okay?
Yeah.
And so you have a larger, and most of those people are overcharged because the system is based upon overwhelming the defense and then taking and trying to force them into plea bargains. So it results into overcharging, whether it's vertical or horizontal, there's an overcharge of the defendant. And many times they wind up taking and pleading guilty to charges for which they never committed, and they wind up being convicted and sentenced on that. And the sentence show. And then you get into the Department of Correction. And if you think that a guilty plea shows you're being contrite, being capable of reforming, if there was evidence that the parole board looked at it like that, they wouldn't take and pass you over to your second or third parole board review before they release you, even after you served a long period of time. So it tells you that the guilty plea doesn't have the merit that it would have for a person that's supposedly throwing themselves to the mercy of the court. The court don't look at it like that. The court knows that the system that beat your ass and put you in front of the court and made you plead guilty. You haven't submitted to anything.
So, Mr. Ben, well, speaking of pleas, I was looking at some of the data, and it was saying how maybe at the time that this was done, I think this was like 2016, because I was trying to find for some current numbers, so you might have more current numbers. But at that time, they only had like maybe 16 exonerations from SBS. But a lot of people take pleas, and based on what I was reading, those plea deals feeds the science to saying, hey, this has happened. Look at all these people who said they did it. But that's not the reason some people take pleas. Some people just take pleas because they didn't do it and they don't want to stay in prison 20 and 30 years for something they didn't do.
That's true.
And you know, if I can say this also.
Go ahead.
See, one of the invidious things, I'm sorry, one of the invidious realities in the state of Michigan, and once again stemming from the Engler administration, is that in the state of Michigan, if a person earns a parole, and make no mistake about it, parole's not just given out, they have to be earned, okay? They have to be earned, all right? So if a person earns the parole, the victim, the county prosecutor, can object to that parole in that circuit court where that case originated from, all right? But if a person is denied a parole in the state of Michigan, you have no legal recourse. You cannot sue the parole board in the state of Michigan, all right? So once again, it is a system where even if you earn a parole, that is subject to be summarily taken away from you, even though you convinced the people that are your jailers, all right? Your jailers. The parole board is part of the Department of Corrections, all right? So the warden and the administrators, all the people work together, all right? So even when you convince your jailers, remember now, your jailers are the ones that have watched you for the last 5, 10, 15, 20 years. That county prosecutor has long forgotten your case. That judge that was in charge has long forgotten your case. They know nothing about you, out of sight, out of mind. But what's so invidious is even people who have an eagle's eye view on you 24/7, they say this man or woman has earned a parole. You are subject to have that snatched at the caprice of a county prosecutor and a county judge who's worried about the next election cycle, and they don't want nobody saying, well, this person was convicted of murder, this person convicted of rape, and you stood by and let them come out in our society. Don't worry about the fact that person's already paid their debt, all right? Because they wouldn't be in a position to get a parole in the first place if they hadn't met that minimum time. You understand? So
Right.
that's why there's indeterminate sentencing in the state of Michigan. It's a bookend, a minimum to a maximum. So whether you do that minimum, whether you do some intermediate time, or whether you do that maximum, of course you can max out, the parole board can't hold you then. But for that minimum time, that intermediate time, you have done your service and paid your debt, because the parole board has said this man or woman is worthy of a chance to reintegrate. And so in Michigan, it's horrendous. And I just hope people can band together to be able to strike that law down where inmates cannot appeal the denial of a parole, and take away the power of these prosecutors to arbitrarily go to these judges and get these paroles just taken away from them summarily.
So that's why we need the reform. So that's why we need to fight for the good time bill to be awarded. I think Linda said something about disbanding parole boards. There's a lot of work to do in Michigan.
Yes, there is. And in regards of our parole system, we done had a policy drift. You know, we didn't have a policy drift in terms of what our sentencing practices mean and what it means to taking parole. You know, Michigan used to have what we call a determinate sentencing practice, where you got a single sentence. And the legislators attempted back in the 1800s, it was near the end of the 1800s, they created a statute that would provide a motion for resentencing when the person had been convicted and sentenced to demonstrate that they had been rehabilitated. And the state challenged it, the prosecutors challenged it, and the Michigan Supreme Court found the statute to be unconstitutional. It said that the statute infringed upon the governor's exclusive prerogative to provide for paroles and commutation and pardons and reprieves. So, but the legislator wasn't through. They was determined to take and provide some relief for those who showed some reform since they had been convicted and sentenced. So they put on the ballot a ballot initiative for asking the state if they would agree, voters, if they would agree to allow the state to provide for indeterminate sentencing for a minimum and a max. And the voters said yes to that. You may provide for that. So we went from taking and having a determinate sentencing statute where we only had a single sentence to where they reserved the single sentencing for the most serious crimes in the state, like for first-degree murder. And but when it came to other offenses, they put a head and a tail on it. And the idea was to allow the parole board to have some leverage, some say in it. But it turned into where they still consider you in many instances, like you both say, they consider you to have to take and earn it, as opposed to taking it after have you served your minimum sentence to be ready to leave. They have it now where even though you may serve that time, they may take you to that max. And that's one of the dangers of sentencing a young offender. When you sentence people who are still in their adolescence to a long tail, you're going to often find the young offenders wind up not getting out until they serve that tail. Okay, if you did statistics, like if you gave a kid 1 to 20, the kid is liable to do the 20 years. You know, because they wind up not being able to find their way out of a wet paper bag because they're going to be judged for being a child growing up in adult space inside a prison. It's already an abnormal environment. These are things that happen in our state, and they're not looked at because we spend too much time demonizing people as opposed to taking and rehabilitating people. So I agree with those who say that we should be in the work, we should be about the business of abolition as opposed to reform. What we call a reform was a reform in the beginning.
Right.
All this BS was a reform, and all we doing is doing like this. Every cycle, every election cycle, every time somebody come around with a bigger voice, it turns one way or the other way. We need to take and go about the business of abolition. Not those of us who are doing this reform stuff, we are, like Angela Davis has said, we are in the damn way. We need to take and acknowledge that what we need is abolition. That's like asking me, the great-grandson of a former slave, do I believe in reforming slavery? Hell no. I believe in abolition. Why would I believe in allowing, and people ask you today, do you believe that you should have what we're saying, defund the police? It's an institution of slavery. These are former slave catchers. What problem do I got with abolishing that? The only reason I'm saying no to it, because there's a disconnect in my mind in the history of it. When you understand the history, you say yes.
Okay. Well, today we have reached our hour mark, a little bit over. This was so good.
Excellent. Excellent.
Yeah. Mr. Arthur, I want to thank you, Mr. Arthur Ben, for joining us. Is there something you would like to leave with the listeners?
Don't never plead guilty if you didn't do it.
Okay, that's yeah. You know, and so yeah.
Absolutely.
I got a friend that went to jury trial, got 300 years. Told me he didn't commit the crime. I believed him. I wrote a brief for him. The Innocence Project took his case in 2011. He wasn't released from prison until 2018. And he pled guilty so they would let him go that day.
Yeah.
Wow.
Yeah. And that happens. I mentioned to you once about the kid out of Macomb County, I think it was. He happens up on a dead body and hit it with a stick, and he ran around, told all other kids he killed the man. They put him in prison for it. Then they turned around and convicted 2 adults for the crime. And the 2 adults say, hey, you already convicted the kid for this crime. You know what the prosecutor's response was? Kid didn't do it. He only said he done it. That was their argument. When the Supreme Court ordered a retrial of the man's case, he got back to court. He was so impatient to get back. He pleaded guilty to get out of prison.
Wow. So while you talking, Mr. Edwards, Mr. Sanders, is there something you're going to leave us with?
I just did. Oakland County or Macomb County should be very proud of what they did. The kid only said he done it. They was proud to say that.
Yeah.
They was proud to say that. We kind of like think Donald Trump is the only bully in the world. We didn't have bullies before him.
Yeah.
And we'll have plenty after him. And many of them are our state officials. As I said, the bigger the degree, the bigger the lie.
Mm-hmm.
I seen a case out of Van Buren County. The guy confessed to killing this person, and they didn't arrest him, didn't prosecute him until 15 years later, with the DNA evidence come back that this guy was the one that committed the crime. And somebody asked the prosecutor, "Well, how come you didn't prosecute him?" We didn't believe him.
Wow. Attorney Hugo Mack.
Well, once again, a great opportunity. This was a fantastic discussion, and
yes.
I'm extremely appreciative of Mr. Bean. First time me seeing you. Perhaps our paths will cross again. Brother Sanders, I like that Mac Street, Mac Avenue thing. When I go on and copyright that, don't ask for no money. And but no, I'm 30-something anyway. So, but it's just encouraging to me and our leader J Love. Thank you. It encourages me because sometimes we're all human and subject to discouragement. But if not for people willing to stand up, we'd have thousands, tens of thousands, hundreds of thousands of people still in the system. And I'm gonna say this to all these attorneys, these defense attorneys talking about how wrong the system is. Get up off your behind and run for some of these offices. All right. Give people an opportunity for change. Give them an opportunity for change. Letting these judges and particularly these prosecutors walk into office, nobody challenging them, because all you doing is solidifying the system when you do that. When you give people no choice, you enshrine them in slavery because there is nowhere for them to go. But a choice is what we got to keep on giving. So that's my encouragement, and God bless y'all from the bottom of my heart.
Yeah, and we want people, we come here every Friday to encourage you, to get you to think, to get you to not just take our word for it, Google, study. We have to be more proactive. When all of us are, what I really want to say is for those who are not involved, if they get just as angry as those that are involved or are impacted, we can make change. But first, we have to listen. When people are telling you their stories, that's why we come on here to tell stories, to get out this information, because no one is really, you hear wrongful incarceration, and then you see a guy who comes home after, 16, 20, 30 years. And then we watch it on the news and then we go about our business. And that's what they want you to do. But we need some accountability because there are too many people that's not going to be on TV. That's not going to be in there 20 years. They 2 years, 5 years. Some of them take pleas, and be on probation of a year or two that are wrongfully convicted. And so we want to bring attention to this because we want to eliminate that. We want to come together and come up with policies and laws to change this from happening. We want accountability. We want somebody to take responsibility for these wrongful convictions.
If the prosecutor causes a wrongful conviction, he should be subject to the same punishment as you just put that person in prison for.
Yes.
That's
yes,
right.
Because like Sam said this morning, they use the their lies and the things that they put off as a weapon to convince you. It was a weapon.
But then when you do get a retrial, they want to continue the lies.
Yeah, no one should be able to stand before a jury and tell a jury that the only way that this could have occurred is like A, B, or C. That's the jury's prerogative to make that decision. That's what they're there for. They are the judge.
Sorry, guys. I don't know what happened. But thank you, everyone, for joining us. We'll be back next week. Mr. Ben, whenever you want to come back, just let me know. You can come back. We have so much to discuss. I was talking to Trisha earlier, and she said so much is going on with wrongful conviction. We could talk about it every day and still be talking about something different because there's so much, there's so many layers. But we want to give this a conversation soon, because I want some of the mothers to come on, or people who have been wrongfully convicted off of this junk science to talk, because we want people to understand that this can happen to anybody. There's no one that is exempt from a wrongful conviction. So thank you guys.
Thank you.
And I'll see you guys next week.
All right.
And I appreciate you all. Bye-bye.
Appreciate being on the show.
All right. Everybody stay safe out there.
You too.
Yes, thank you.
Thank you.
Wear your mask. Wear your mask when you're in public.
Yes.
Yes.